Hello and welcome. My guest today is attorney Jeff Homuth. Mr. Homuth attained his bachelor's degree from the University of Michigan, then went on to receive his law degree from the University of Minnesota. He worked as an associate attorney at McCollum Crowley law firm from 2007 to 2013. Then in 2013, he began work as a staff attorney at the law office of John C. Syverson Liberty Mutual Insurance, where he still works today practicing workmen's compensation insurance defense. Mr. Homuth is also my big brother. Mr. Homuth, thank you for coming on the show.
Hi, Mr. Homuth. Thank you for having me.
So many students were curious just off the bat how and why you went into law. Can you tell us a little bit about that?
Thanks. Well, I think people get into law for a lot of different reasons. My path, I wasn't born saying I'm gonna be a lawyer. Like this, I want to be like the people on TV. This is what I want to do. I think in my case, it just kind of gradually over time decided that this was the best fit for stuff that I felt like I was good at, or things I could offer a workplace someday. So I knew.
So a little bit of background about what me and my students will be doing. We're going to be participating in a mock trial in the next few weeks. The historical figure Julius Caesar will be on trial for treason against the Roman Republic. So as someone who has experienced court trials in your work as an attorney, what should students expect?
Right. So I guess there's a lot of formality to the proceeding. We'll talk a little bit about maybe like people's perceptions of what goes on in a courtroom versus the reality. But I think the main thing is that there are a lot of rules, both for behavior, both for things that you can say, ways that you can present arguments. It's not just a free-for-all. You can't just you may have a lot of reasons why you believe your position is superior or why you think your client should win the case, but you have to kind of fit that within the rules of what the court will allow you to do it, when they'll allow you to present that evidence, and what type of evidence you're actually allowed to present, and so forth.
What should students do to prepare for the trial, but in order to do everything they need to in order to present their best case? What would you recommend?
Sure, but to answer your question, the preparation for that, or really for any formal proceeding, it's really the critical part. The percentage of time that I'm actually in a courtroom arguing in front of a judge is actually a really low percentage of the overall job. Most of the job in real life is counseling my clients what they should do in a situation, and then if we're going to go into a courtroom setting like you're going to be doing, I'm getting prepared so that I have my information together and that I've thought ahead of time what might happen and also what the other side might do in response to what I'm going to say.
So kind of planning out your strategy, but also trying to anticipate the other side's strategy?
Yeah, that's really important. And I think a key thing that some of the people who are best at it do is that if you have a weakness in your argument, or if you know something's going to happen in the trial that's not going to be positive for your side, you don't want to run from that. You want to address that head on. And if you're the prosecution, or if you in the course of the trial have the chance to talk first on it, you actually kind of get to set the narrative for that by framing it in the way that's more favorable to your client. And that's actually your whole job as an attorney, is just to put your client in the best position possible so that they can win the case or get a good outcome.
So it sounds like you're describing that there's not just one narrative to present what happened in whatever case you're looking at. And that's something in history class we talk about all the time, is that there's not just one story, there's different perspectives, and that can change how you look at it.
So one of the things in a real trial that you can't do is leading the witness when it's your own witness.
So what does that mean, leading the witness?
Basically, the questions that you ask, they can't suggest the answer to the question to the witness when it's a direct examination of a witness. And there's a very important reason for that, which is it's not really about the attorney. It's about the information in the case. The attorney has an important role. It's not the attorney's job to make the argument and then kind of put in their head. So if I'm asking you a question, I'm like, yeah, you were over there on that night or whatever. Like I've just suggested the answer. Like you were doing what we talked about before or whatever. I've just suggested the answer to your question. I need to ask you simply, can you please tell me what you were doing on the night of last Thursday or something? Well, you still can frame the way that the question comes up, the answer comes out, but you're not doing it in a way that gives them the answer or suggests what they should be saying. You're not giving them kind of a script verbally. So that's the important difference. Now, when you're cross-examining a witness, which means you're asking questions of the other team's witness, it's different. You can ask leading questions. You can ask them yes/no questions because you're not trying to control their testimony. You're actually trying to kind of contradict their testimony. Right. But the important thing there is to kind of control what they're going to say by the questions you ask, not giving them the chance to over-explain or to kind of meander off into other topics. You want to then be in control of the questions that you're asking so that you know, or you think you know, what they're going to answer. The answer itself will be beneficial to your case, not any answer that you fed them.
Okay, great. Some additional questions here, getting into kind of some more details during a trial. One concept that might be new to a lot of us here is this concept of the burden of proof.
Okay.
Can you tell us what that is, first of all, and then what does that mean for a criminal trial?
Well, there's two things to know about it, really. So the burden of proof in a criminal trial particularly, it's who has the burden of proof, and then what is it. So let's start with the who has it first.
Okay.
In a criminal case, the prosecution, the people who are bringing the claim or the charge against someone else, they carry the burden of proof on we'll just say for all important points of the case. There are some exceptions, but
Sure.
By and large, because they're charging someone with a crime, they have to meet a standard, which is the burden of proof of convincing a jury, of getting basically other people to agree that a crime has been committed. In terms of what that burden of proof is, it differs in the type of trial.
Sure. Now, that also ties in with this concept of innocent until proven guilty, right? The burden of proof?
Yeah, it's a similar concept, kind of in reverse, but that basically by placing the burden on the prosecution, and it's not this way in some countries and in some legal cultures, in America, when you're charged of a crime, they place the burden on the people who are accusing you of the crime as a benefit to you of protecting your legal rights or preventing you from being unduly prosecuted or having,
Sure.
because it's a very serious consequence that follows obviously from being found criminally guilty.
Absolutely.
All right, history buffs. Part 2 with my interview with Jeff Homuth is coming soon.